Well, welcome everyone to the first of our ERISA webinars here for 2022 at Matthiesen, Wickert Lehrer. I am Ryan Woody, and I'm joined by Nancy Case, my partner here in Wisconsin, and Katherine Dowie of our Boston office. Again, my name is Ryan Woody. I'm a partner here at Matthiesen, Wickert Lehrer. I've been here in our Wisconsin office since 2004. And while I was just saying that kind of makes me feel old. But I've been doing health and reimbursement work here for health plans since those early days of ERISA subrogation, I guess. Lately, I've been doing a lot more ERISA defense work, in addition to all of the traditional property and casualty subrogation work that we do here at MWL. But alongside me is Nancy Case and Katherine Dowie, and I'll let them both quickly introduce themselves here to the audience. Nancy, go for it.
Yes, hello. Hi, everyone. Thanks for joining us. My name is Nancy Case, and I got involved in subrogation probably around 2005. I was recruited to a labor and employment law firm who was representing a large pension and welfare fund. And my job was to handle all of the subrogation for the Chicago Laborers Health and Welfare Fund. So if you can imagine, every carpenter, every mason, plumber who got in a car accident or involved in a workers' compensation matter, I was able to negotiate the subrogation for the welfare fund on those matters. And an interesting situation, because there was a committee, there wasn't a plan administrator making decisions about settlements. I had a committee, half labor, half management, sometimes with competing viewpoints on how to settle subrogation matters. So great immersion. I sort of fell into the role, but I stuck with it. And then we happened to have a laborer who got into an accident in Wisconsin, and I had to research someone to be able to help me perhaps litigate that matter. And that is when I discovered Matthiesen, Wickert Lehrer, and met Ryan Woody, and we stayed in contact for several years, and I've relied heavily on Ryan, and still somewhat today, to work through some of these more difficult matters and litigation. And I joined Matthiesen, Wickert Lehrer in 2015, and I've been here ever since, handling subro.
Thanks, Nancy. Katherine?
Hey everyone, thanks for joining us. My name is Katherine Dowie, and I actually started with subrogation fresh out of college. My first job after graduating was with the FIA group. I was in their subrogation department for 6 years, and after my first year with them, I actually applied to law school. Started going to classes at night while I was, handling files during the day. I was heavily involved in all of their matters that do reach litigation, which is how I got in touch with Ryan and Matthiesen, Wickert Lehrer. I left the FIA group to take a clerkship in the District of Connecticut, and then I was actually out in Wisconsin with Ryan and Nancy for a year. I also clerked in the Northern District of Ohio, and I just wrapped that up in September, which is when I came back to Boston and opened up MWL here.
Thanks, Katherine. So I don't know about everyone out there, but I can say that for us here, we've missed the opportunity to do those in-person conferences and see and meet everyone and talk about the those day-to-day issues that are affecting us all. So rather than waiting for everything to return to normal, we thought it would be great to kind of kick off 2022 with this this new webinar series dedicated to ERISA subrogation and reimbursement issues. Our aim each month is going to be to touch on some high-level topics, break down some recent cases, and I think above all, try to answer some of those tough questions that everyone has. Talking about questions today, there is a way for everyone, if they've got questions, to send in questions to us. There's a question box along the interface, and so if you've got questions, you should be able to send those, and I'll be able to see those, and either we can answer them during the presentation, or we'll get to them afterwards, or possibly incorporate them into next month's webinar. Today, we're going to start out by highlighting kind of the dilemmas that we all face after the underlying personal injury case settles. And suddenly we're told, by the attorney that he's going to be dispersing the funds to his client, and he gives us an arbitrary deadline to respond. The Supreme Court's decision in Montanile, I guess it changed really how and when we must respond to those type of notices. So in this first webinar, we're going to kind of focus just on that. What practice and legal steps must we take to respond to these disbursement threats? In the second half of the webinar, we're going to turn our focus to evaluating settlement offers that often accompany litigation decisions. What does ERISA have to say about settlement offers and decision making? What obligations do we have, and do we have to document that our rationales when we settle those cases? And then finally, we'll turn our attention to a couple questions before previewing next month's webinar. So just to kind of start off, I want to talk about the Montanile decision that came out, gosh, now it's probably about 5 years old or so, and discuss the Montanile letter, quote unquote. So I think first it's important for everyone to understand, where Montanile came from. What are the facts of Montanile, and how do they relate to the claim that you may be handling. So first, it's important to know Montanile involved a $500,000 settlement and a $121,000 ERISA lien. So after the attorneys took their half, the member netted about $240,000. Ultimately, by the time that litigation happened, there was only about $90,000 left. And the lawyer in that case had sent a post, after they had settled it, sent a letter advising the plan that it had settled the case and they were going to disperse if they didn't hear any objections from the plan within 14 days. Well, the plan in that case didn't object within that 14 days. Rather, they did what we thought was normal at the time, and they engaged in negotiation, trying to see if they could settle the case rather than have to litigate it. They spent about 6 months going back and forth till they ultimately realized they were not going to be able to settle the case, and then finally they pursued litigation. And so the case below wasn't the main issue in the case below. I think the main issue in the case below was whether the plan could enforce its SPD if that was the only document, and that kind of this disbursement issue was kind of the secondary issue in the case. But ultimately, when the case went up after the plan had won at both levels, the issue at the Supreme Court was whether the plan could recover here where the funds were dispersed and dissipated. Ultimately, the Supreme Court held that a plan's equitable lien by agreement could not attach where the settlement funds were both dispersed and dissipated on non-traceable items. So that's kind of important for us to understand. So Montanile does not mean that you cannot recover after the funds have been dispersed. So in other words, if you get that letter and the attorney has sent the funds to his client, that doesn't mean you can't recover. So dispersed is one thing, but it also has to be dissipated on non-traceable items. So in other words, the participant took the money that he got and he went to the casino and spent it all. Or the participant got the money and she spent it all on her student loans, repaying those student loans, or spending it on credit card debt. That's not the typical situation. It may happen in smaller dollar cases, or it may happen on occasion, but let's be clear that a lot of times these are bigger settlements and that money goes into the bank. That money might get spent on a traceable item like a vehicle, or might get put into home equity. That's not going to preclude you from potentially tracing and recovering on those cases. What we're concerned about are the smaller dollar settlements. We're concerned about those where the money is then gone and spent at the casino or spent on credit card debt so that we can't recover it. Montanile does mean that you cannot simply negotiate in good faith for 6 months after the funds have been dispersed. You cannot just ignore these Montanile letters, and you must be prepared to litigate or potentially risk breaching that fiduciary duty that the plan owes to all its participants. So the point of today's webinar is to talk about what we can do before those Montanile letters come in. What can we do to avoid that mad scramble that we all face when those letters come in? Because we all know, what may be coming. What can we do now to avoid that scramble? Why don't you jump in and kind of lead us through what can we do? What's the first step that any plan stakeholder can start doing before this situation occurs?
Well, the first thing they're going to want to do is make sure that they have, all the language that we want to see in the plan document. We want to make sure that there's a subrogation and reimbursement section, that it clearly outlines their rights. The plans definitely want to make sure that they're working with a TPA or a subrogation vendor that can proactively identify and begin sending out notice letters on these cases. And the first thing that you're going to want to do when you get any case as a vendor, as a TPA, as whoever is responsible for putting those attorneys and insurance companies on notice, is make sure that you understand what the plan's rights are, and that's always going to start with the documents. Pretty much every case that you handle, you should know what the summary plan description says, and you should know what the 5500s look like. Those are documents that you're going to be asked for in almost every case, and so you want to make sure that when you start your file, those documents are included in it. Now, if you've got a case,
I just want to kind of to explore that with you, because a lot of times I know that we'll get cases sent over, and all that will come over with is like with a benefits booklet. And what are your thoughts on whether we can rely on a benefits booklet alone?
Unfortunately, you really shouldn't be. The Supreme Court has been very clear, Signa via Mara, that what actually controls is the plan document. The summary plan description might be helpful. Ideally, the summary plan description and the plan document are going to be the same document so that you don't have to go looking for conflicting terms. But in addition to Montanile, one of the cases that we all know is the McCutcheon decision. We throw that one around all the time. It sounds at the Supreme Court level like it went really well for US Airways, right? If you look at how that case turned out when it went back to the trial court, not only did US Airways end up with almost nothing from their subrogation and reimbursement claim, because as it turned out, the language in the plan document wasn't as good as what was in the summary plan description, which is what it was litigated with at the Supreme Court. But because they hadn't turned over that plan document, they ended up owing fines. So US Airways actually ended up out money in that case, even though you'd think just looking at the Supreme Court decision that it was so positive. And so on any case, certainly of any significant size, if you have any doubts about whether the document that you have is actually the plan document, that's something that you should be following up for. And if you're listening to this and you're a TPA maybe, those are the kinds of things that you should be asking for in your onboarding process, and not just relying on those summary plan descriptions, because you want to have those at hand quickly. I've seen cases like you talked about, Ryan, where we get all the way where the plan has authorized litigation. They want us to file suit. And I ask for the actual plan document, and no one knows where it is. Sometimes nobody knows what it is. They're like, do you mean this, short little document that we rarely use? That's the document that governs everything. And so you want to make sure that that has the language you want to see in it, and you want to make sure that the people handling your files have access to those documents quickly.
Yeah, and I think that we make this sound like it's a simple issue, but it's given the makeup of how, you know, plans contract with a TPA, who then contracts with a subrogation vendor, and that TPA may issue the SPD, you know, and if they change TPAs the next year, a new TPA issues an SPD. But I find it that not everyone understands that the group may actually have its own overarching plan document that they use, in addition to the SPD that gets generated by the TPA. And so one of the things that I think that has to be done, and I think Katherine suggested the onboarding process, you know, is probably the best way to do it. So we're not, you know, trying to do this every time we've got a particular claim with the group. It is to ask about the plan document, because the group came in either with an SPD that someone else issued, or they came in with an overarching plan document, right? So it's important, you know, we'll be asking those questions if you send us a case. So it's important to kind of do that due diligence during that onboarding process. Nancy, do you have any thoughts on that? I know you've run into issues where groups have dusted off something from the last decade that they call a trust agreement or a plan document.
Yes, absolutely. And I have run into situations where there have been modifications to the subrogation language or some other material part of the plan, and we would need that as well. The other thing to think about too is that I've run into a situation where the SPD had very strong subrogation and reimbursement language, and spent a lot of time trying to get to the ultimate plan document to, because you need it in order to draft the complaint. If you're including that, you know, the reimbursement language in your complaint, you absolutely need to get that right. And I've had situations where the actual plan document says, if there is a component plan, you know, say it's one employer that has subsidiaries, sometimes it speaks to the plan document being controlling, and other times it will say, unless this language is inconsistent with the component plan SPD, you know, all of which is important operative language when you are in federal court. So yeah. I agree with all of that. I sometimes I feel like I'm really bothering people, and it takes a while to get to that document, but it is critical. It's absolutely critical.
Yeah, and we got a question there from the audience, just kind of on topic here, about what happens if the benefit booklet has been incorporated by reference in the plan, as the plan document. And I think that obviously you've got to scrutinize the incorporation by reference language that's used by the group and in the document, because sometimes there can be conflicting language. You know, the benefit booklet may say this is not the benefit booklet, this is not the plan document. But if it gets properly, you know, the short answer is if it's properly incorporated by reference, then it can be enforceable. But sometimes you've got to kind of walk that back and see if, well, was it properly incorporated by reference? You know, was there a formal resolution that was made, that was signed? You know, the number of times I've seen unsigned documents that are purporting to be, you know, an amendment or the SPD, you know, so it's just important that you track that down. But in theory, yes, it can be incorporated by reference. Sorry to cut you off, Katherine.
No, not at all. So I think the next document that everybody really needs to be thinking about on any file of significant size is a copy of the stop loss policy. So step one is you want to know, what is the specific deductible in this case? Have we exceeded it? Are we at a risk of exceeding it? Is there going to be stop loss involvement? If there's any chance that there's going to be, you want to make sure that you're looking at that policy and seeing, does the stop loss carrier have some kind of right with regard to approving the settlement? Typically, the stop loss carrier will have a first right of reimbursement from any money that's returned. That's not always the case, but it's often the case. You also want to see, is the stop loss carrier going to be able to step in and litigate the case, even if the plan makes the determination that maybe it's not cost effective, or maybe that's not something that they're interested in, given their exposure aside from what stop loss is paid. Those are all going to be really important questions if you are considering litigating the matter, especially when you're thinking about how our fee is going to be distributed, when the money comes back, who's going to get that first. What you want to do is try to prevent any back end fighting that's going to stop you from being able to actually settle the case. Once you're really starting to think about litigation, other documents that you should probably get on hand because they're likely to be requested in discovery, and just as a practical matter, they're going to be helpful for the plan and for us, for the lawyers handling the case, are things like the administrative services agreement, vendor agreements. And when you're really thinking about litigating is when it's really crucial to make sure, like Ryan just said, that you have actually signed copies of everything. You know, maybe early on in the case, you could trust that somebody's sending you an unsigned document and you can trust that it's executed. But once you actually get down into discovery, you're going to need the executed copies of those agreements, and you're going to need to make sure you know the dates that they were effective, because remember, you may need multiple copies of all these documents because you need to know which one was in effect on the date that a specific claim was incurred. So if somebody's been treating for 2 or 3 years, you're going to need to make sure that you have the executed copies in effect on all of the relevant dates.
Did you hear that, Nancy? So that means those redlined Word versions of an SPD that you sent over is just not going to be good enough.
Okay.
And darn it, that plaintiff's lawyer who won't accept that. I don't know. But okay, so Catherine, once we've got the documents, you know, like those key documents kind of housed or assembled for the file or for the group in any particular claim, what's the next thing that we should be doing to kind of understand the lay of the land on a particular claim, the available recovery sources, and why is that important to gather and know before you get the Montanile letter?
So it's important to know as much as you can before you get the Montanile letter, because you want to know what all of your both options and limitations are. And so early on in the case, you should be trying to make sure that you're having an actual conversation with whomever is handling the file, whether that's potentially a conversation with the injured party and the litigation adjuster if there's not an attorney involved, or if they've hired an attorney to pursue the case, to talk to them. Are we worried about potential policy limits issues? Is there a major issue with whether or not certain claims are related? Is there going to be UIM or umbrella coverage involved? And so maybe we're thinking about settlement in particular stages. Is the claimant a minor or someone who can't handle their own financial affairs? So we have to worry about whether or not there's going to be some kind of compromised court hearing, but almost more importantly, are we worried about that money going into some kind of trust for the future benefit, where once the money goes into that trust, that's going to impede our ability to recover the money and get the money out of the trust. One thing that can be really important is to look into whether or not you have access, for example, to, if the underlying case is being litigated, the docket, because plaintiff's counsel may not always give you as many updates as you'd like. They might not be proactive about reaching out, but they're going to tell the court, hey, we need to move our dispositive motion deadline because we've settled, and so we're just waiting to finalize that agreement. And so the more access you can get to what's going on in the case without just relying on either following up some irrational amount of times or relying on plaintiff's counsel to proactively reach out to you, the better of a position that you're going to be in.
Sure. And I want to get both of your takes on kind of a trend that we've seen the last 4 or 5 years, definitely increasing the last couple of years, is, do we change the way that we handle these files or negotiate the claims based on the presence of a lien resolution vendor? And does that dynamic change the analysis at all? What do you think, Catherine?
I'd say absolutely. A lot of these vendors, first off, one thing that it means when you see that a vendor is involved is that you are going to be asked for every piece of paper that the plan has ever touched related to forming their plan, subrogation and reimbursement claims. You know, these vendors aren't necessary, their goal isn't necessarily to determine what the plan's rights are and then just tell their client, okay, here are your obligations. Their goal is to make sure that they get some reduction. And so if your plan has good language, if there aren't any issues with producing the actual plan document, if the Form 5500s are filled out correctly, those vendors are still going to come back and say, well, we want more, or, you know, if you don't think this is worth your time, you can just offer us a reduction. And so the incentives there are really problematic. The other huge problem I've had with multiple lien resolution vendors is that if you're just dealing with them on reductions, even if they ultimately approve a number, they're not the ones typically actually in possession of the funds. And so I've had circumstances where they've negotiated within some prearranged authority that they have with plaintiff's counsel, only to find out later on that plaintiff's counsel dispersed the money because they didn't realize they were supposed to hold it in trust. And so you need to make sure that you are ensuring that you know where that money is and that you're copying plaintiff's counsel on all those communications, even if really who you're dealing with is the resolution vendor.
Right. So, I mean, because it seems to me that the lien resolution vendor, the way that they operate with their multiple arguments and requests for different documents that seemingly are endless, is that they end up dragging you into that Montanile situation where you're negotiating for 6 months. And, you know, I think unless you've got something in writing that assures you that the plaintiff's lawyer is holding those in trust, those funds, you know, we're back to that Montanile situation where we have kind of been lulled into a false sense of security that the funds are going to be there. Nancy, what are your thoughts on that?
I agree with everything both of you just said completely. And I would also add that typically if I get involved with a lien resolution person, number one, I absolutely copy the plaintiff's attorney along with that, but I also try to get authority from the plan to litigate or at least draft a draft complaint. That seems to have an impact and to reduce the amount of time it takes to actually settle the case. And I don't treat them any differently than I would treat a plaintiff's attorney. You know, it is the member's obligation to reimburse the plan, and I just couch my language and our negotiations in that basis. I don't treat them, you know, any differently than I would, or say, oh, well, you know, a lien resolution person is involved here. It doesn't matter to me. So I would just add that. I try to get right to litigation authority. And again, draft complaints, they do have an impact.
Yeah, Catherine, here's a question from the audience when it comes to like some maybe over-the-top document requests. There is a question about, well, hey, I'm getting these requests for copies of the checks, you know, proof of payment, right? You know, they don't like my itemization. That's not enough. I've even provided EOBs, but they say that's not enough. What do you think about having to actually produce copies of checks to the extent that that actually exists?
So there's certainly not a legal requirement pre-litigation that you're going to have to provide copies of checks. That being said, two things. One, if that's really the only holdup, you'd likely need to produce them in just if they were requested in discovery. And so that's something that you might want to consider. The other thing that I often talk about with clients when I get requests for copies of checks, and it seems like, you know, producing that might actually make a difference, is that doesn't necessarily mean that you need to produce every single check for 80 pages of claims or something like that. Oftentimes, what the person is looking for or is hoping to be either dissuaded or convinced of is that the money actually came from a bank account that is controlled by the plan, by the employer. And so, you know, maybe you want to consider, especially if there's one or two larger charges, seeing if you can get that one piece of paper and see if that'll stop any roadblocks in negotiations or help you resolve the case more quickly.
And then another question came in kind of along the lines of your your last answer about the lien resolution vendor is, well, what happens if you do settle in writing with the lien resolution vendor and find out later that the funds have been dispersed and they don't honor the lien? Is there a remedy, or is there a separate breach of contract claim that can be brought?
So ultimately, both the lien resolution company and plaintiff's counsel are acting on behalf of the member. And ultimately, if you're dealing with an ERISA plan, all of those tracing requirements that we've talked about in Montanile and disbursement are going to apply. And so that's why it's so important to make sure that you're involved, that you're finding out where those funds are at all times as soon as you find out that the case is settled, and making sure that whoever is in possession of those funds knows it's going to be an ethical violation to disperse them.
And I would add that I haven't often, because I don't really come across that very often, but I would have no problem naming the lien resolution group as a defendant, as a necessary party, if I don't have firsthand knowledge of where those funds are. You know, I've thrown that into negotiations. And again, I'm just trying to get from here to there as quickly as possible. And because that's a possibility, again, sometimes it creates some action.
Yeah, I think we might have to do a whole topic on lien resolution vendors, because I'm getting so many questions in from the audience on it. It seems like everyone shares the same frustration. But one of the other, I guess, kind of transitioning, you know, to the next topic here is well, how do we bring in, you know, all of these stakeholders when the time is of the essence? You know, first of all, it's not just as simple as someone getting a hold of someone at the TPA or someone getting a hold of someone at the plan to authorize litigation. It can be a lot more complicated than that. I wanted to kind of just share with everyone one example of a case that Katherine and I were involved in not too long ago, where I think despite our best efforts to get all the stakeholders on the same page, we still kind of failed. I mean, it doesn't mean we didn't end up with a good result at the end of the day after the litigation had settled, but just to kind of give you an example of where things ended up going off the rails, it was you know, not an atypical case. It was a suit filed by an employee's son against the plan after he had recovered from a third party and a UIM carrier. The bulk of his recovery was for UIM, and there was a state statute in that particular state that says, well, you can't subrogate against an insured's UIM recovery. And so he filed an action, basically a deck action against the plan, arguing that they didn't have a right to recover under that statute. You know, there were issues involved. You know, stop loss was involved, and so that became an issue. That became an issue in why they were arguing that the state statute applied. But it also became, you know, kind of an issue getting them as a stakeholder on board. They were kind of, I would say the stop loss carrier was obviously the financially driving the case. They had the lion's share of the interest if there was going to be a recovery by the plan. So we had to explain things to the employer group, and you know, about how the reimbursement worked, who had the claim, etc. After we explained that to the CEO, you know, we answered and filed a counterclaim for the reimbursement. The case, you know, really proceeded as normal. There was a lot of discovery about, you know, even into the checks, who was paying, how was the plan really self-funded, how did it operate, and that happens when you get into really deep into the litigation. The case kind of proceeded as normal until right at the end of discovery, when the plaintiff's counsel dropped a bombshell on us. That bombshell was that the son's father had surreptitiously called the company's CEO and recorded a conversation where the CEO stated that the company was not pursuing the lien and that they were waiving their interest in any recovery. And that attorney had nicely taken that recorded call and had it transcribed nicely with a case caption and everything. And so obviously what the CEO of the company didn't really understand was that, the stop loss carrier's interest in being reimbursed was not something that was separate and apart from the plan's overall claim for the entire amount that had been paid. So by waiving the company's interest, he was arguably waiving the entire interest, including the stop loss carrier's interest. So, despite our best efforts to explain the process to the CEO, he failed to mention that one had taken place to us. So we were caught off guard, and this was unfortunately one of those states where one party can record a conversation without the other party's consent. So I say that story to kind of tease out some of the issues that we have in bringing all the stakeholders on board. So Katherine, any suggestions on how to first identify all the stakeholders in an ERISA case and how to best bring them to the table early on?
So I think one of the best opportunities to bring everybody in early on is actually when you find out that there might be some kind of stop loss implication, because that's a great opportunity to make sure that you're reaching out to everybody, getting everybody on the same page, even if there's not an underlying settlement quite in sight yet. Even if you don't have any kind of stop loss implication, I would encourage everybody involved in these cases to get to the actual plan, the actual decision maker, as early and as often as possible if you think that there's going to be any kind of problem with the case, if you think this is a case that might one day end up in litigation. No one downstream from you is ever going to get mad at you for sending an FYI email. Look, we're having this issue. We're hoping that we can settle within the authority that we have, but I want to let you know that if everything goes wrong, we might be contacting you really quickly for litigation authority, because when someone's threatening a disbursement of funds, that happens in an instant, and we need a decision on whether to pull the trigger just as quickly. Now, getting all those people on board can take a really long time. In a typical case, you've got a case handler at a subrogation vendor who might have to go through a manager or a client account manager to reach out to the TPA. Whoever's at the TPA might have a similar protocol regarding a management or a client account manager. The TPA's contact may not be the plan directly, it might be a broker. When you finally reach out to the plan, oftentimes the primary contact might be somebody in HR who's used to dealing with enrollment forms and kind of base level questions, but not necessarily somebody like an executive who's going to be able to make an actual decision about a substantial reduction or litigation. Even once you get to an executive, perhaps it's a plan like the one Nancy used to work for, where there's a committee that has to become involved. Or that person higher up might want to talk to somebody in in-house legal or even outside counsel that they typically use for business disputes. And just because you've got a lawyer involved all the way down the line doesn't mean that it's a lawyer that necessarily has any understanding of subrogation matters. We work in a really niche industry. This isn't something that you should expect just someone who does more generic commercial disputes to have a full understanding of. And so especially when we send a draft complaint to somebody and say, well, you need to file this now, the plan may want to take serious time to consider, do we want to sue our employee? And in the case of disbursed funds, I've gotten a lot of pushback from in-house counsel and from outside lawyers who are more involved with the company about making ethical complaints against plaintiff's counsel if we're saying that they've disbursed funds despite the fact that they're on notice of the lien. And so if you know that you're going to have that kind of trail of communication and potentially trail of miscommunication, if there are going to be people along that line who are going to be maybe reformatting your message or not, like simply forwarding it on to the next person, the quicker you can establish a chain of communication with the decision maker, and the sooner that you can start educating the decision maker, the better.
Well, let me ask you about maybe what I think is probably a fairly common dilemma. Is that, you know, with these self-funded plans, you're going to have stop-loss carriers all over the board. You know, in some instances, they go with a TPA, and that TPA is a large insurer, and they place a stop-loss, so you don't have this conflict. But if you're not dealing with one of those big carrier situations that's acting as the TPA, and you've got stop-loss at a different, you know, at a different company this year or another company the next year, and let's say we're handling the group's subrogation claim either through the TPA or a subrogation vendor. How do we best go about getting the stop-loss carrier or carriers on board, you know, with the recovery? And a lot of times, you know, I guess I say this because, you know, they take the position in many cases, in some cases, I guess, that they're entitled to full reimbursement, and are they willing to pay, you know, the per part of the cost of collection? How do we get those kind of fee issues taken care of, those nasty, you know, things that are in the background that no one wants to talk about, is, you know, because everyone's got a, you know, a fee built into some contract. How do we get those on the same page?
So first things first, we're going to go back to the documents. You want to make sure that you have the stop loss contracts, and that you either have the contracts or at a bare minimum understand the fee structure of any vendors involved. And that's where you're going to start in most cases, because you need to know, does the plan really have the option to just walk away and turn this over to the stop loss carrier? How involved do you need to make the stop loss carrier? And the other thing that you want to make sure that you're doing, even before you get all those documents, is that you're not running into one of the situations like we ran into in that case, where the plan is potentially prejudicing the rights of the stop loss carrier, potentially running into a, you know, breach of contract issue with their stop loss carrier, by not fully pursuing the reimbursement to the extent that it's reasonable to do so. The earlier you get the carrier involved, and the earlier you let them know, you know, you have the major interest here. If this needs to be litigated, that's something that you're going to need to contribute to make sure that it's worthwhile for my client to pursue it. Or if it's not worthwhile for my client to pursue it, we won't waive anything. We'll make sure that, you know, if the stop loss contract has assignment rights, we'll fully comply with those. But you're going to need to step in and take over and actually handle this matter if you think we need to be more aggressive, if you think that the plan's recovery interest needs to be pursued more aggressively than is cost effective for us to pursue it.
Yeah. And kind of along those lines, and I've been kind of, you know, I've had a situation where we almost got burned but didn't. Is the situation where the plan changes TPAs across plan years for a particular injury, and you have different TPAs that come in and pay, but it's a self-funded plan, so whether, you know, XYZ carrier is paying as a TPA, doesn't mean XYZ carrier has that interest. It's still the plan's undivided interest. Is how do you get those different TPAs on board when the plan needs to file suit to include, you know, payments across different TPAs? Because that, to me, that is more challenging than getting, you know, one or two stop loss carriers on board.
Yeah, so I think one of the first things you need to figure out is, are there limitations that are going to mean you can't get full reimbursement? Because in cases where you can get full reimbursement, maybe both TPAs or both the vendors who work for the TPAs have some ability to think about, do we both want to be involved in this? But ultimately, I think those kinds of agreements and those kind of you know, pushing forward as though it's really two different liens isn't going to be beneficial to the plan, because all it's going to do is create substantial confusion with plaintiff's counsel. The other problem that you run into in those kind of situations is, are you using TPAs or vendors that have very different negotiation strategies, very different contracts in terms of their internal authority? And so in those cases, it is absolutely critical to make sure that the plan is making a decision about how aggressively it intends to pursue reimbursement, because you don't want one plan offering a 50% reduction, or one TPA or one vendor offering a 50% reduction and the other only offering a third, unless maybe there's a really good reason for that, like that later treatment might not be related or something like that. But making sure that you get everybody together so that you can coordinate those negotiation efforts is really going to be critical.
Yeah, I feel like Nancy wants to jump in here because she just got done with a case like that. No?
No, I think that Catherine laid it out very well.
Here's one that's not quite related, but it's on the topic of stop loss. Someone wants to know, hey, is there a distinction in litigation when the stop loss carrier pays a very large percentage versus a very small percentage as far as determining whether state or federal law applies? And so I comfortably answer that question that no, it doesn't. You know, the distinction between whether state or federal law applies doesn't turn on the amount that has been reimbursed by stop loss. The circuits are all pretty much aligned in treating self-funded ERISA plans as self-funded, regardless of the amount that's been reimbursed by stop loss. Now, I say that with a caveat that it depends. I'm very much aware that there are certain plan designs out there that raise some concerns over whether the plan is really self-funded. They're kind of set up by stop loss carriers, and they may have very, very small self-insured portions, whether it's amounts less than $25,000 per individual per claim, or they may somehow cap the plan's overall exposure. Those are different questions than the amount the stop loss carrier has reimbursed. If it's a traditional plan that's self-funded, you know, up to a decent amount, so that it's not just a large deductible type plan, then there's no issue with that. But there are complex plan design questions that I don't want to get into in this seminar on that issue. And so one of the other things that, before we jump into, I know Nancy's eager to talk about the settlement issue, but I wanted to just touch on is this issue of TROs, because I think that there's a misconception out there that, you know, Montanile's not a big deal because I can just hire you know, Nancy or Catherine or Ryan to go out there and get a TRO, and you know, I don't really have to worry too much about this because, you know, judges are going to grant these TROs, and you know, there's some truth that, yeah, I mean, a TRO is not always that complicated to get, and it's something that we can do generally on the briefing with you know, a declaration from the client. And you know, we can get it after, you know, generally a Zoom hearing these days. But what I think that some clients may not fully appreciate, and it's important that we get all stakeholders, you know, to the table before we run it and do anything like that, is that the next step after we get a TRO is very involved. The court is required to set a preliminary injunction hearing. That can be, you know, 2 weeks off, it can be a month off, but that is an evidentiary hearing where we have to bring people with personal knowledge of the plan, its funding, the claims in this case, and they testify at that hearing. And so, you know, running to get a TRO is not a decision that we take lightly, and we need to get all decision makers to the table before we decide to do something like that, just because of the significant immediate demands that it requires on plan witnesses. And if you don't have the group on board and all of a sudden, I'm calling, because I need them to testify at a federal hearing in a week, let's just say we want to avoid that situation. But before I guess the next thing that kind of comes to mind is that a lot of these cases, again, we ultimately will make a decision not to litigate, whether because there's an offer on the table and maybe we need to analyze that offer. But how do we do that? How do we analyze these last minute settlement offers that may come in conjunction with the Montanile letter? What exactly does ERISA say about how a fiduciary should evaluate those offers? So to discuss that next topic, I want to kind of turn to Nancy, who's going to touch on those considerations that need to be documented and taken into consideration.
Okay. Yeah, because it's a very important consideration. And my background, as I discussed earlier, was dealing with a committee of decision makers, a committee who, had the final authority on settlement. And I often, our viewpoint of representation was from an ERISA compliance standpoint. So I think it's important to understand what a fiduciary duty is and how it comes into play when you're settling subrogation matters. So basically, a fiduciary duty is a person or a committee with a duty to act in a way that will benefit someone else, usually financially. So it's a financial interest. And they hold a legal or ethical duty of trust with one or more parties. So the plan administrator holds an ethical duty to all of the plan members, taking care of money or other assets. And in this case, the assets are the pool of money used to pay participants' claims. And a good case to take a look at is the 11th Circuit Court of Appeals went to great lengths to lay out all of the rationale for subrogation and third-party recovery activity and why it's a requirement of any benefit plan administration to honor the fiduciary duty. And that is the Zurich v. Keith O'Hara case from 2010. And the court held that the primary purpose of ERISA was to ensure the integrity and viability of bargain for benefit plans, and that those plans must be enforced as written. So that should always be your starting point. So plan fiduciaries must assure that the assets of the employee health plans are preserved in order to satisfy future and present claims of all plan participants. So they're not always looking at the case individually. They've got a broader duty. So now the ERISA statute does not speak to subrogation or reimbursement specifically, but the statute does speak to the standard of care that plan administrators need to be concerned with when settling these matters. And that is 29 USC section 1104. And it is called the prudent man standard of care. So a fiduciary shall discharge his duties with respect to a plan solely in the interest of participants and beneficiaries with care, skill, prudence, and diligence under the circumstances. And this duty is for the exclusive purpose of providing benefits to the participants and for defraying reasonable expenses of administering the plan. So there's a lot to think about. So so denying the plan its right of reimbursement would harm other plan members by reducing the funds that are available to pay claims. So when a waiver or a reduction is requested by plaintiff's counsel or whomever, when it comes time to settle a case, the first thing that the plan administrator or you as the negotiator need to think about is to advise the person asking for the reduction of the plan terms and the duty to enforce them. So if the plan terms say 100% priority reimbursement without attorney's fees, whatever the plan language is, educate the other person that that's our starting point. It is a fiduciary duty to enforce those plan terms. So the second thing you need to think about is, or discuss, is the ability to exercise discretionary authority. So there is discretionary authority to waive or reduce on these cases, but they're based on the facts and circumstances of the matter at hand. So no broad-based 1/3 reduction because you took it almost to litigation. There can be no hard and fast on this point. It has to be the individual facts and circumstances of that case. So what are the facts and circumstances? And, you know, again, you're having this dialogue. And what you want to know, or a plan administrator needs to consider, is the total settlement amount. So is there enough money there to reimburse the plan in full, or is it a limited settlement? Sometimes if it's a limited settlement, that opens up a whole different negotiating strategy. So number one, you want to know that. Then you want to understand the status of the claim or the litigation. So did you get the settlement money with a couple of phone calls, or did you take it to the, you know, steps of the courthouse, doing all the discovery, depositions, everything that involves experts, fees, and that goes into the next element to consider, which is, you know, what are the participants' out-of-pocket costs? What were the expenses to litigate this matter to secure that recovery? And then, you know, this is a little bit of a tricky one, but you want to know, you know, what's the attorney fee? You know, even though your plan term may say we don't care about attorney's fees, it's a consideration. You know, are they taking 40% of the total settlement? Or in a limited settlement situation, are they reducing their fee? Because they're certainly telling you all about their client and how, you know, they're not going to be made whole. You hear that a lot, that the reduction is, or that the settlement is limited. That's a factor. Are they reducing their fee to be able to get the settlement done? So, you know, once you have all of that done, part of the fiduciary duty is to document all waivers and reductions. You need to document them, find a way to document them. And why do you want to do that? Because if the Department of Labor ever comes along and decides to audit the plan, they will review all subrogation and reimbursement matters to determine if the plan terms are being enforced as written. So all kind of circling back to the ERISA compliance piece of it. And if the plan terms aren't being reinforced, the Department of Labor is going to want to know why not. So
is that your empty threat, or have you actually seen that happen?
I have actually seen that happen. I've been involved with plans who have been penalized, and then part of their cure is to come up with an elaborate process within the plan about how to settle these matters. You know, how they process the claims, how they approach settlement, what their guidelines for settlement are. Again, if you're enforcing plan terms that say 100% reimbursement, you know, what are the considerations? And I just named a few. Does the plan administrator, decision maker, need to think about and document in order to settle the case appropriately, you know, and in ERISA compliance? So, you know, this everything's negotiable approach is actually consistent with the plan administrator's responsibility to execute their fiduciary duties. But
I think what you're saying is they've got to document the facts that explain that decision.
Absolutely. And when I'm on the, you know, when I finally settle a case, I will send to my client, you know, or the TPA, the plan, I will say, you know, I'm confirming settlement of the subrogation matter for a 20% reduction based on, and then I will list out what it is. You know, the settlement was this amount, they litigated it or didn't litigate it. And I will just lay out the facts and circumstances, just have that written documentation of confirmation of settlement of the subrogation matter. So it exists. I know it exists because I know it's important.
Here's an interesting question that came in.
Okay.
I don't want to take this because it looks like a hard question. So Nancy, could a plan have a rule that they need not, where they don't have to reduce, must get 100% no matter what? Is there a distinction there between a funded plan, a plan that takes employee contributions versus an unfunded plan? So I guess let's just tackle the first part of that. Could the plan have a rule where they have to get 100%, no reductions ever?
No, not necessarily. In fact, it you know, if litigated, a court would find that not reducing when appropriate is a breach of a fiduciary duty. So holding hard and fast to a must have a 100% reduction does not always accrue to the plan's benefit, especially if there is a bad faith claim that comes your way as a result of that. And the time and expense the plan would incur having to defend that litigation is not a good use of plan assets. So you have to be.
I guess in ERISA terms, it would be a breach of fiduciary duty claim. But I think that one of the answers is, okay, well, sometimes you have to abandon a claim where the costs of pursuing it simply outweigh the expense of pursuing it.
Absolutely.
From a financial standpoint. Now, maybe there are situations for sure where a plan may do that just to set an example for the rest of the group. But I think ultimately you want to document any of these reasons. And I think that it just doesn't make economic sense to say for a rule like that question had, is where you are pursuing 100% in all situations, no matter the facts, no matter the expense.
Yeah, that is inappropriate. That's why I actually use the term guidelines, and have had to talk with plan administrators. And in my last position, from a compliance standpoint, you can have guidelines. You cannot not have hard and fast rules. So it gets a little bit squishy, but that's kind of what we're here for, to help you walk through those issues, and they can get complicated. But you don't want to fail on the fiduciary duty standpoint.
Well, thank you, Nancy. I think we're going to try to jump to our conclusion here and kind of wrap up. But if anyone's got any specific questions on the grounds that we covered today, feel free to email us, contact us. You can go to www.mwl-law.com, find our information. I want to close with a couple questions here, and then kind of preview our next month's webinar. So Nancy, I've got a question to you. The question is related to your topic about how past settlements are treated by maybe audited by the DOL. But if we get into litigation, I guess the question is, can a plan participant compel the plan to produce evidence of all its past subrogation recoveries from the other plan participants to demonstrate the arbitrary or disparate treatment of this particular member?
Well, funny you should bring that up, because I've heard that argument before. I will have a plaintiff's attorney say, well, I happen to know for a fact that on this plan's settlements, they always allow a 50% reduction, or whatever the assertion might be. But from a legal standpoint, well, of course, never say never. These cases, as you probably realize by now, can get very complicated and weedy. But the courts have considered this issue and have suggested that the answer is no. The plan cannot be compelled to produce evidence of past settlements, because the duty of the case in front of you, and kind of reinforced that earlier, is that you are looking at this particular case and you are enforcing plan terms as written. So a couple of courts in Board of Trustees versus Moore have actually termed such a request a fishing expedition masquerading as discovery, because it's really not relevant. What's relevant is the here and now case before the court. The other case is Bill Gray Enterprises case, which is a fairly widely known case. Specifically states that past interpretations have no relevance where terms are unambiguously, or where terms unambiguously require reimbursement. So again, the focus is always on the plan terms as they are today with this particular case that's being litigated.
Thanks, Nancy. And then Katherine, the question I have for you is I pulled one of my favorite questions from our nemesis, Professor Barron. He circulates talking points about how you can challenge plan subrogation rights. This is one of my favorites because it's so out there. But oftentimes we get these goofy questions that come in, and you're like, well, where's the case that proves he's wrong? Who's addressed? Where's the authority? And so the question, the goofy question is, does a plan commit an unconstitutional taking under the Fifth Amendment when it seeks recovery from a personal injury recovery?
So as you kind of teed up, no. And that's one of the problems with the really goofy questions, is that sometimes someone says something so obviously insane that nobody has said it to a court before, and so no court has had to specifically say, no, you're crazy. In this case, though, I'd point you to Administrative Committee for Walmart Stores versus Salazar, which is a 2007 District of Arizona case, which points out the obvious, which is that ERISA plans especially are not government actors just because they're, taking steps in accordance with a federal statute.
Thank you. Thanks everyone for attending. It's been fun. We're going to continue to do these until no one wants to hear from us anymore. So next month, we're planning on March 22nd at the same time. We'll 12 p.m. Eastern. We'll send out an invite to everyone that was on this webinar. We're going to be covering wrongful death claims and claims by minors. That was one of the topics that a lot of people requested, so we're going to cover it. In addition, last week, the Eighth Circuit released its opinion in the Virtualino case, handled by my good friend Noah Lipschultz, and that case addressed a reimbursement claim by a minor against a minor's recovery. So kind of piggybacking on the momentum of that case, we'll tackle that issue and some of the unique issues that come up in cases involving minors. We'll also go ahead and try to deal headlong into some of the strategies you can take in dealing with the always difficult wrongful death claims. Again, we'll answer 2 audience questions that you've pre-submitted. We'll try to pick out the most difficult ones and tackle those. So feel free to email me or any of us those questions that you might have in the interim, and we'll answer them. Again, that'll be Tuesday, March 22nd at 12 Eastern. We'll send out the invites soon. So thanks again. If we've got some questions, I see we do, we'll try to get those answered to you and back in the interim. Thanks, Catherine. Thanks, Nancy. We'll look forward to you next time.
All right. Thank you. Thanks, everyone.